Yes, Mr. Hammond.
My Lord Lewison posed a question before the short adjournment. What power did the Rules Committee have to change the law or the law of jurisdiction or remove a common law requirement if such common law requirement existed? My Lords, in answer to that, we've not addressed that in advance, simply because it was not a point taken by my learned friend on this appeal. But if it is a point taken by my learned friend, we have 2 points in answer. First point is that all the cases we've been looking at this morning have been construction cases, construing the rules. And they've all proceeded, or the judges in those cases have all proceeded on the basis or assumption that the Rules Committee did have the power or ability to change the law in relation to jurisdiction. In the time available over the short adjournment, my learned junior, Mr. McComb, has, and I'm grateful for it, unearthed an extract from Briggs on civil jurisdiction and judgments. May I hand that up to my lords? In which we say the editor of that book, Mr. Briggs, reaches the same conclusion.
Just a minute, just let two of my colleagues get it.
Mr. Briggs reaches the same conclusion as the judges and all the authorities that we've looked at, that they were able to proceed on the basis or assumption that the Rules Committee had that power. Well, this paragraph 1.05 at the bottom of page 5, with the heading Service and Jurisdiction.
Yes.
The introduction is this: a fundamental characteristic of the common law's approach to jurisdiction is that it equates jurisdiction with the service of process. And we, pausing there, agree with that on the basis that the rules provide a code, and we would say a comprehensive code for litigants to follow. The defendant who has not been served at all is not or not yet subject to the jurisdiction of the court. The defendant who has been served in full conformity with the rules governing service or not is subject to the jurisdiction of the court. For it is service and only service and always service and nothing but service that gives the court personal jurisdiction over the defendant. Put another way, service is the act which creates, crystallises the jurisdiction of the court over the defendant in relation to the claim. And then, and this is the important bit in relation to powers, service of the documents which institute legal proceedings is therefore not merely a notification that such proceedings are about to begin, but is the very act which gives the court jurisdiction over the defendant in respect to the claim set out in the documents. The material rules, by which I assume Briggs means procedural rules, of English law, such as they are not rules of jurisdiction, but rules about service which have jurisdictional consequences. When the relevant committee, the relevant rules committee, alters the procedural rules about the service of documents, it is altering the rules which define the international reach, the jurisdiction of the court, without any overt recognition that this is what it is doing. It is the strangest thing. Certainly a decision to alter the rules about service of process is not preceded by the kind of grand projet put in place when the European Union was considering making changes to its rules of jurisdiction. So, Lord, that was the extract that we identified over the short adjournment, and we say that that textbook, at least, operates on the same assumption as the judges in the cases that we looked at this morning, which is that it's a question of construction of the rules, and they were all entitled to proceed on the basis that the Rules Committee had the ability to change the law of jurisdiction.
What's the next paragraph all about? The result can be that the defendant is made subject to the jurisdiction of the court in circumstances in which this should not, even manifestly should not have happened. If the matter is disputed by the defendant, the application may lead to the court declaring that it does not have jurisdiction, even though it does have it, or until the moment of its decision in order did have it.
And that's dealing, my lord, with the academic question of if service is affected by a claimant, because it's the claimant that affects service, not the court, then one has a position where, for the time being, the defendant is subject to jurisdiction by reason of the steps taken by the claimant. But that jurisdiction can be wound back by an application by the defendant to set aside or to challenge the validity of the service.
And that happened in this case, didn't it? There was an application to disputing the court's jurisdiction, I think.
In this case, indeed, leading to Mr. Justice Bryan's
Yeah.
decision that there was a declaration of validity of service and therefore jurisdiction, indeed. Concludes that paragraph, my lord, is reading with sort of academic point that one goes round and round in circles as to whether, in fact, jurisdiction has been established if the method of service is later rendered invalid.
Which the answer might be it's been defeasibly established, or at least provision of it, or subject to the possibility of reversal.
Something like that, but I don't think the niceties of the quality of the jurisdiction for that period is particularly relevant on this appeal. And the final point, in answer to my lord's point, we do refer back to the decision in Kamali, and in the authorities bundle, Lord Justice May's judgment at paragraph 329. Where at paragraph 14, Lord Justice May addresses the submission made to him by Mr. Woolman. Paragraph 14, Lord Justice May recalls that Mr. Woolman has covered many pages and made oral submissions today with reasons why the CPR should not be construed and applied, as in my view the decision in Rolf's case substantially requires us. And he says they mostly depend in essence on the proposition that service on a defendant who has to be within the jurisdiction at the time is an entrenched principle which cannot be abolished by an inexplicit side wind of secondary legislation, which should accordingly be construed as not abolishing it. In my judgment, this overstates the durability of the so-called principle. Of course, it applied in the days of personal service, so Lord Justice May there, my lord, is going on to the history of the fact that when there was personal service, the requirement of presence was relevant. He says, for personal service could not otherwise be affected, but things have moved on, and we've had service by post for over 35 years, now by other means as well. And then at paragraph 15, Lord Justice May says, now that service by post is permitted, it makes little sense that its effectiveness should depend on the chance that the defendant happens not to be abroad at the time. The service is in accordance with the rules. The CPR are not removing an entrenched principle, since the so-called principle has not applied in the county court for more than 35 years. And of course, that's a reference to the decision in Rolf having been binding for since the county court rules came in. So that was how Lord Justice May dealt with the question of the power of the Rules Committee. And then finally, Lord Justice Neuberger's judgment of paragraph 32. He says, the common law rule identified in Chalaram has, in my opinion, been displaced by the provisions of the CPR. So in 32, Lord Justice Neuberger, again, like the Briggs textbook, was working on the basis that the Rules Committee, by setting rules of service and procedure, have the power or ability to alter the jurisdictional position.
Thank you.
My lord, with that, I was going to move on to the second topic on this appeal. Our position is that if I'm wrong and the common law anterior requirement exists, it was satisfied in this case, and Mr. Justice Bryan was right in finding it satisfied, and he was right for the reasons he gave. Lords, I take 4 preliminary points. The first point is that it's common ground that actual physical presence is not necessary to meet the requirement. Temporary absence from the jurisdiction does not result in a person not being subject to the jurisdiction. That's in my other side, my learned friend's skeleton argument, and paragraph 60 of Mr. Justice Bryan. The second point is that we say it's important to assess the factual circumstances as at the date of service, and not with the benefit of hindsight, or taking into account ex post facto matters. Mr. Justice Bryan's task was to assess the circumstances at purported date of service, which is what he did. Well, our third point is that in this case, somewhat unusually, as at the time of service, we now have Mr. Justice Bryan's established finding, for which permission to appeal was refused, that Athlone House was, at the date of service, Mr. Fridman's usual residence. I'll come on to look at Mr. Justice Bryan's finding in relation to that. But just for completeness, there was a ground of appeal to challenge that finding of usual residence, and no permission was granted in relation to that ground of appeal. So we say the consequence of that is that it is with that established finding of usual residency that this court must assess whether Mr. Justice Bryan was wrong in his decision that the common law requirement of presence was made out. And the judge's decision was an evaluative decision that the anterior requirement of presence was made out, the judge applying a multitude of factors to come to that decision. And for your lordships to find that Mr. Justice Bryan was wrong, we say there must be some identifiable flaw in his treatment of the question he had to decide, or failure to take account of a material factor which undermines the cogency of his conclusion. The fourth and final preliminary point is, critically, as at the date of service, and stripped of any hindsight, there was no information as to how long Mr. Fridman's designation as a sanctioned individual, or how long the travel ban would last in the face of his legal challenge to his designation and his stated intention to return to the UK once he was able to. So, Lords, with those preliminaries, may we look at Mr. Justice Bryan's findings and reasoning. His judgment starts in the core bundle, page 76. And we make the observation that before reaching his conclusions, the judge's judgment demonstrates that he took into account all relevant factors surrounding Mr. Fridman's sanctioned status. And the starting point for that is paragraph 15 of his judgment on page 80 of the core bundle. Paragraph 15, Mr. Justice Bryan starts by speaking of Mr. Fridman's indefinite leave to remain in the UK, and there being no doubt that Athlone House, where he resided, was his usual residence. Indeed, during the course of the oral submissions before me, Mr. Nicholas Craig KC, who appears on behalf of Fridman, confirmed that that was not disputed. But then importantly, however, subsequently, on the 15th of March, Mr. Fridman was designated under Regulations 5 and 6 of the Russia Sanctions EU Exit Regulations and Part 1 of the Sanctions and Anti-Money Laundering Act. Mr. Fridman's assets were frozen in consequence. In addition, he became an excluded person within Section 8B of the Immigration Act, and this means that his leave to remain in the UK was cancelled and he is not permitted to enter the UK with travel ban. So we say that demonstrates that Mr. Justice Bryan was cognizant of Mr. Fridman's position as a sanctioned individual. Then dropping down on page 81 to paragraph 20, the judge records that following his designation, Mr. Fridman was granted a number of licences by the Office of Foreign Sanctions Implementation, which is part of His Majesty's Treasury. However, the OFSI refused to grant licences to make certain payments to AHL, that was Athlone House Limited, which concluded a service contract with Mr. Fridman for the purposes of managing Athlone House. This refusal was challenged unsuccessfully by Mr. Fridman on an application before Mr. Justice Saney in the October, and the sanctions judgment recorded. And then he sets out there a passage in paragraph 1 of Mr. Justice Saney's judgment, which records that as at the date of the hearing, which is the 17th of October 23, remember service in this case was in March 24, Mr. Fridman had left the UK for Israel and then travelled to Russia. However, he has informed the court through his solicitors that he intends to return to this country, and as a result of the sanctions described in more detail below, that return will not be possible because he's an excluded person and subject to the travel ban. Lord Mr. Justice Bryan then records the submissions made to him down at paragraph 50, subparagraph 3, which is on page 88. This is my client's submission, which is recorded by Mr. Justice Bryan. He says here, Mr. Fridman's absence from the UK was held out by Mr. Fridman himself as being temporary, not permanent. As set out above, Mr. Fridman informed Mr. Justice Saney that he intended to return to the UK, a statement that was made in the context of his existing challenge to his designation, which might be determined favourably and soon. And in the meantime, Mr. Fridman was continuing to maintain his residence and staff in the UK in the same way as formerly, including staff for personal services. Finally, by the time of March service, only about 6 months had elapsed since Mr. Fridman had departed from the UK, so the intervening period had not been long by then. So that was the submission made to him in relation to the designation as a sanctioned individual and Mr. Fridman's challenge to that designation. And then for fairness, my learned friend's submission is recorded at paragraph 53 on page 89. Mr. Fridman submitted the court should decline jurisdiction over the claim. He refers firstly to SSL and the principles identified by Stanley Burnton, or Justice Stanley Burnton, in that case in relation to the common law and the CPR. In relation to both such matters, in essence, he submits that applying the principles in Schulman, Mr. Fridman ceased to be resident in the UK in September, and after his departure from the UK and as a result of the temporary travel ban, he ceased to be within the jurisdiction, and there was a distinct break in pattern in his life. His residence in the UK, it is said, ceased. In such circumstances, it was submitted that the claimants cannot establish that Mr. Fridman was present in the jurisdiction at the time, or that Athlone House was either his usual residence or his last known residence. Well, that's the background and the setting out of the submissions relevantly to this issue. And then Mr. Justice Bryan's conclusions start at paragraph 60. Where he says the first point that arises, this is on page 91, is in relation to the common law position about the court exercising jurisdiction against those who are within the jurisdiction. It's clear from SSL that temporary absence does not result in a person not being subject to jurisdiction. In this regard, it is quite clear that Mr. Fridman's stance has always been that he intends to return to the jurisdiction. Indeed, the position is recorded at paragraph 6 of Mr. Justice Saney's judgment, which provides as follows. And then he sets out an important paragraph from Mr. Justice Saney's judgment to this effect. The designation of Mr. Fridman under the Russia regulations, that, I should say, was a defined term, meaning the UK sanctions regulation, is the subject of legal challenges brought by Mr. Fridman. The present claim is not concerned with those challenges, and I must proceed on the basis that he has been lawfully designated for the reasons given by the Secretary of State. I should, however, recall that Mr. Fridman has publicly expressed his opposition to the Russian invasion of Ukraine and condemned the war as a terrible tragedy. So, my Lord, in that paragraph, Mr. Justice Bryan is citing SSL and making the point that temporary absence does not result in a person not being subject to the jurisdiction. He records it's quite clear that Mr. Fridman's stance has always been an intention to return. And he cites Mr. Justice Saney's judgment, recording the fact of Mr. Fridman challenging his designation as a sanctioned individual under the UK regulations. And obviously the fact that Mr. Fridman was challenging his designation is of significance, we say, to the question before my lords and the question before Mr. Justice Bryan.
But if we're looking at this part of the case on the assumption that there is a requirement of physical presence which would include temporary absences. If someone is not physically present and for the time being is prevented from being physically present, but says I intend to come back if and when I am able to do so, doesn't whoever is deciding whether the person is physically present within the jurisdiction, barring temporary absences, have to evaluate the prospect of that intention, that wish, if you like, being put into effect? As Lord Justice Asquith famously said, you can't intend it to be a fine day tomorrow. All you can do is hope that it will be, or wish that it will be. And that if you have a wish to do something, but there are so many hurdles in your way that the prospect of that happening are remote, you can't really be said to intend it.
Well, we say, and I'll come on to show how the judge dealt with this, we say one can combine, as Mr. Justice Bryan did, the fact of a challenge to the jurisdiction with that individual's intention to return, with his residency status within the jurisdiction. To posit an extreme example, his sanctions status could have fallen away the day after service had been effected, such that his absence was extremely temporary, because in line with his intention, he would have returned the day after service had been effected at Appellant House. One can, in this part of the appeal, one can posit the alternative scenario at the other end of the spectrum, where a sanctioned individual, upon being sanctioned, leaves the jurisdiction, cuts all ties with the jurisdiction, does not retain a property here, has no intention of returning, and publicly states that fact, and does not make any legal challenge to their designation. That sanctioned individual, I would submit, is at the opposite end of the spectrum to the sanctioned individual we're dealing with in this case, where Mr. Fridman is someone who has a usual residence in this jurisdiction. That's the finding that Mr. Justice Bryan made, which is unappealable. Stayed at that usual residence for 18 months whilst he was sanctioned, because he was sanctioned in March 2022 and didn't leave until September 2023.
I thought I read somewhere he was entitled to do that while his challenge was still pending.
I believe that's my learned friend's point, yes. He's launched his legal challenge to that designation. He's maintained a residence here. He's stated publicly an intention to return once those sanctions are lifted. And he expressly regards himself as a resident, as we'll come on to, before the courts, because he said so before the General Court of the Grand Chamber of the European Union. Lord, ultimately we say each case turns on its facts. It's a multifactorial inquiry, and the way Mr. Justice Bryan dealt with it was correct and reasonable, given the factual matrix before him. Well, I was at paragraph 60. The next paragraph in Mr. Justice Bryan's findings is paragraph 61.
Yeah.
Says it's also clear, I have already quoted, that Mr. Fridman's position in front of Mr. Justice Saney was that he intended to return to the UK. It's also clear that Mr. Fridman was representing himself as still residing in London, not only at the hearing on the 11th of January, but he had not disabused the General Court of the Grand Chamber at the 11th of September that remained his position. So the hearing, Lord, before the General Court of the Grand Chamber was on the 11th of January 24. They gave judgment on the 11th of September 24, spanning the period in which service was affected. And Mr. Justice Bryan goes on, he represented, as is recorded at the beginning of the Grand Chamber judgment, that he was, quote, Michael Fridman residing in London. The next relevant paragraph is paragraph 63, which we say is more of the same. Mr. Justice Bryan says, I do not consider that there is any substance in what was effectively Mr. Fridman's preliminary point in relation to the common law position. It's well established that where there is temporary absence, that does not result in a person not being subject to the court's jurisdiction. It was at all material times the intention, again, referring to the intention that Mr. Fridman would return to this jurisdiction, and indeed the evidence suggests that he was even representing that he was residing in London at all stages throughout. And then, paragraph 64 over the page, the suggestion that Mr. Fridman was no longer resident in the jurisdiction that is now sought to be advanced on his behalf is notably not supported by any witness statement from him. It's difficult to see how such an evidence could credibly and appropriately have been led by him, given his stance before both Mr. Justice Saney and before the General Court, and what Mr. Justice Bryan describes as the bright light that such evidence sheds on Mr. Fridman's own intentions and belief. And we say Mr. Justice Bryan, taking into account the lack of any evidence direct from Mr. Fridman and weighing that fact against the facts that were apparent from the two cases that he had advanced in public, was a perfectly permissible approach. And then 65, and the first 3 or 4 lines of 65 are critical, because this is Mr. Justice Bryan's conclusion. He says, applying the principles in Schulman and having regard to the matters set out below in relation to Mr. Fridman's usual residence and last name residence, I am satisfied that at the material time, Mr. Fridman did not cease to be resident for jurisdiction purposes. And he concludes at 66, I am therefore satisfied the court had jurisdiction of common law to exercise jurisdiction over Mr. Fridman. Now, just dwelling on those first 3 lines of paragraph 65, what Mr. Justice Bryan is doing there is he is applying the principles that were laid out in the decision of Schulman and Kolomoisky. Why was he doing that? He was doing that because it was Mr. Fridman's submission, at first instance, that the Schulman requirement was the relevant test. And we see that at paragraph 53 of Mr. Justice Bryan. And indeed, Mr. Justice Bryan sets out the test at paragraphs 40 and 41. But also from the first 3 lines of paragraph 65, it's important to see that Mr. Justice Bryan also has regard to his own findings in relation to Mr. Fridman's usual residence and last known residence, which of course are findings that are not subject to appeal today. And Lord, we find Mr. Justice Bryan's findings as to usual residence down at paragraph 67 on page 92, through to paragraph 70. My Lord, we say these are critical passages. It talks about at 67 as being the heart of today's application, the question of usual residence. Mr. Fridman is a sanctioned individual, which makes it impossible at this moment in time to return to the UK. Just pausing there, the judge was absolutely cognizant of the draconian nature of the sanctions that Mr. Fridman was under. Goes on, whilst the claimants realistically accepted that this represents a distinct break in Mr. Fridman's life in the UK, on the authorities and as already addressed, a distinct break is not determinative of the usual residence issue. The inquiry required in order to determine the issue at the heart of this application is a multifactorial and fact-dependent evaluation in which all relevant circumstances are considered in order to see what light they throw on the quality of the individual's absence. Dropping down to 69, the judge observes that Mr. Fridman has not been in a position to use Appellant House since leaving the UK on medical grounds, but it remains the family residence, and I consider that there is very much more than a good arguable case that his residence has not ceased. There are a number of cumulative reasons, he says, why this is so, applying the multifactorial approach, and then he sets them out in numbered paragraphs. Importantly, subparagraph 2 refers to the intention again, as expressed by Mr. Fridman. Subparagraph 3 recognises that Mr. Fridman himself sees his absence as temporary and not permanent. And then subparagraph 4 says this: against the background of the ongoing challenge to his designation, Mr. Fridman's intention to return to the UK and thus Appellant House, if and when his designation has been lifted, is clear evidence that Mr. Fridman at the time of service, and indeed at all times thereafter, continued and continues to consider and treat Appellant House as his usual residence within the jurisdiction, and that his intention to continue his life at Appellant House, as soon as he is able to do so, is remaining his usual residence. At the time of his departure, it could not, of course, be known that the events in Ukraine, which led to the designation, would continue to apply, or for a significant period of time, or indeed that his designation would continue for a significant period of time. Certainly his conduct shows an active intention throughout, and from the moment of designation, to have such designation lifted, and to return to what had throughout been his usual residence. And well, finally, before I make my submissions on this, the subparagraph 6, another point that impressed itself upon Mr. Justice Bryan was that Mr. Fridman had chosen to receive correspondence at Appellant House, notwithstanding his absence. And that correspondence should await his return and not be forwarded to him. Mr. Justice Bryan, 5 lines down, says, I consider that this is a point of some considerable significance that sheds further light as to what was and is Mr. Fridman's usual residence. Mr. Fridman clearly regarded it as his usual residence to which he will return, and so temporary is the absence in his eyes that the post should await his return just as it would whenever he was away from home for whatever reason. And then finally, paragraph 70, on the evidence before me, I'm satisfied. The test of usual residence is there. And that decision on usual residence is, as I said, part and parcel of Mr. Justice Bryan's conclusion that the common law requirement of presence was made out as he stated expressly in paragraph 65. And what we say about all of that is that Mr. Justice Bryan is squarely taking into account Mr. Fridman's sanctioned status and the impact on his travel, and that he cannot lawfully re-enter. The judge was cognizant of all the draconian effects of being sanctioned. But what the judge did was, and we say properly so, he weighed against that the evidence of Mr. Fridman's stated intention to return, the fact of his ongoing challenge to his designation, and that he continued to treat and regard Appellant House as his residence. And we submit that Mr. Justice Bryan took into account the multiplicity of evidence before him, as he was required to do. He was entitled to take into account the evidence he did, and Mr. Fridman is not able to point to an identifiable flaw in the judge's treatment of that evidence, nor point to any material evidence or factor which the judge failed to take account of.
Could I suggest a possible flaw? On this hypothesis that the common law principle applies, we have to, don't we, look at exactly what the principle is. And it isn't just a principle based upon physical presence. The principle is that by virtue of presence, you owe allegiance and obedience. That's the justification for assuming jurisdiction over somebody. And the analysis is, well, the fact that somebody has left temporarily doesn't mean that they cease to owe allegiance and obedience for that temporary period. So that's why it isn't just presence, it's effectively whether or not you owe allegiance and obedience to the jurisdiction. But in this specific instance, unlike the other cases which just look at presence, period, when you're going to return, etc., your connections, here we have a very specific situation where this jurisdiction has passed laws which exclude Mr. Fridman from the jurisdiction. They say, you cannot come back here. And that has been the state of play for a year in relation to the law, and 6 months in relation to his inability to return. Now, in that situation, how can one say that Mr. Fridman still owed duties of allegiance and obedience to a jurisdiction which was expressly excluding him?
Can I try to answer my Lord's question this way and to pose the question, what was intended by Parliament when it introduced and imposed the sanctions regime? Could it really be said that by subjecting an individual to sanctions, Parliament intended also to remove the ability of a bona fide claimant to bring a claim against a person in this country if the circumstances fell within the rules? In other words, if the circumstances of that individual fall within the civil procedure rules as to service, that should still be sufficient.
Here we're not looking just at the rules, are we? We're looking at the principle.
We are. Posit this scenario.
Forgive me, but what Parliament has decided is this is somebody who should not be able to reside here, should not be treated as somebody with any rights, let alone allegiance or obedience to this jurisdiction, because they shall be excluded. No rights at all in relation to this jurisdiction.
My Lord, in that sense, I think it's really an answer to my learned friend's point in their replacement skeleton argument, where they say Mr. Fridman has no right to benefit from this country's laws, and equally he is therefore not amenable to the process of its courts. And what my learned friend does is cite the Adams Cape Industries case and talk about, without, the expression used by my learned friend is without the smooth, as it was described in Adams and Cape, there's no rough to accept. We say that point ignores the fact that sanctions are supposed to be draconian. The idea of sanctions is to remove what Adams and Cape describe as the smooth, the benefits of our laws. And the purpose of sanctions is to add as much rough as possible, to adopt the wording of Adams and Cape. That trade-off, that quid pro quo in the Adams case is simply not applicable, we say, in the context of sanctions.
So you say that what sanctions entail is that you cannot reside here, but you can still be treated as residing.
Indeed. And particularly on that point, Lord, Mr. Justice Bryan found that notwithstanding Mr. Fridman's sanctions, he resided here because he had a usual residence here. And that finding of fact of usual residence is not subject to appeal. So my lords are stuck with that finding. And indeed, throughout the period, to explore this a bit more, throughout the period when Mr. Fridman was sanctioned individual, but still actually present in the United Kingdom, he was able to engage our systems and laws by applying for and obtaining various licenses for expenditure of money on items including money on his house and the maintenance of that house.
But many foreigners can engage with our jurisdiction without having to be present here.
We can.
So I'm not sure how that answers the...
Well, I come back to my rough and smooth analogy. And just to finish off the point I was making about what the intention of Parliament was, did they intend to remove the ability of a bona fide claimant to bring a claim against a person in this jurisdiction? That sort of bona fide claimant could, of course, include Her Majesty's government as a claimant, or a British citizen who may have a claim against someone like Mr. Fridman. And should that claimant be deprived of the opportunity to sue Mr. Fridman in this jurisdiction by reason of his sanctioned status?
Well, that's a false dichotomy, because if Mr. Fridman is not present in the jurisdiction, that doesn't remove the right to sue him. All it means is you have to ask for permission to serve out.
Indeed, my lord, but I dealt with the point earlier about service
Yes.
out. If
Yes, you say you can't serve out.
Can't serve out.
I've got that. But to say that is either service as of right within the jurisdiction or no service at all which is what you've just been saying, is, I would suggest, a false dichotomy.
I take the point. I suppose another way of putting it is this. Mr. Fridman is banned from this jurisdiction. He's banned from being present. And that's what my learned friend's argument is, and he should not be sued here. But of course, we accept that that ban and that sanction status is a relevant factor, as Mr. Justice Bryan did. But another factor which is also relevant is the intention of that individual and the status of that individual with his usual residence here. And I come back to the point I made to my Lord Justice Lewison about there's a spectrum of different sanctioned individuals we could all think of, and we say that this particular individual is at one end of the spectrum given his intention to return. And if I can just develop that point a bit further, the submission is that our submission is that Mr. Justice Bryan's judgment records a detailed evaluative decision of a first instance judge, which was a fair and correct balancing and analysis of the quality of Mr. Fridman's presence or absence as at the relevant time. He plainly understood the anterior common law requirement of presence because he cited Lord Justice Stanley Burnton's judgment in SSL. He asked himself the correct question by reference to that judgment. He was addressing the position of an individual, not a company. And so his appraisal by reference to all the surrounding facts of that individual's circumstances was appropriate. In particular, the factors that weighed heavily on him and which he gave weight to were Mr. Fridman's stated intention and his residency. Can I just take those two in turn in a little more detail? As to residency first. In assessing the question of presence, the court we submit is to assess the quality of any absence in the context of the quality of a person's usual presence in the jurisdiction. And for an individual, the quality of presence or relevant presence can be assessed by reference to residence. And we say it is difficult, in fact, to think of an alternative basis for assessing the quality of an individual's link to the jurisdiction other than residence. The other side, my learned friends say that Mr. Justice Bryan applied an inapposite test for presence because they bluntly applied the test in Shulman. First, that lies ill in my learned friend's mouth because it was the Shulman test that was put before Mr. Justice Bryan. Secondly, all that Shulman actually does is say that the inquiry is a multifactorial and fact-dependent evaluation, which we submit must be right. And there's an example of an assessment of presence by reference to residence in the authorities. Because if I can take you to the decision of Mr. Justice Tier in the Libyan Investment Authority case. This is a case, this is at tab 23 of my Lord's Authorities bundle, page 449. This is a case that came after SSL in the Court of Appeal and proceeded on the basis that SSL was correctly decided and binding. And therefore, Mr. Justice Tier was considering and applying the common law requirement of presence. And relevantly, at paragraph 61, which is on page 460, Mrs. Justice Tier says this: on this question of law, I do not consider that I can improve upon the analysis of the relevant authorities by Mr. Justice Warren in the Clavis case. That case concerned the service of a witness summons on persons who lived in Jersey. They did not reside in England, held they had no presence within the jurisdiction to found personal jurisdiction. Mr. Justice Warren reviewed the relevant authorities, Chellerham, Kamali and SSL. I gratefully adopt the analysis. the relevant statement of principle, which comes from the Court of Appeal and SSL, and so is binding on this court, is to be found in the judgment of Lord Justice Stanley Burton. He sets that out. And then at paragraph 64, Mr. Justice Tier says this: Lord Justice Stanley Burton said that the statement was correct if read with that qualification. That is a reference in my judgment to understanding Mr. Justice Lawrence Collins' reference to persons present in the jurisdiction as meaning persons subject to, i.e. within the jurisdiction. That is why Mr. Justice Warren said at 30 that that was required. What was required was jurisdiction over a person because of a relevant presence within the UK. One such relevant presence is, as Mr. Justice Warren and Lord Justice Stanley Burton recognised, residence within the jurisdiction. The person resident within the jurisdiction is subject to the jurisdiction of the court. Well, that is, on any view, equating residence with presence for these purposes, or at least using the quality of someone's residence as a relevant yardstick for presence. And if it is right that residence equates to presence, which we say it does, we are dealing with this appeal in the context of a finding of fact by Mr. Justice Bryan of usual residence of Mr. Fridman at Appellant House at the time of service. Well, the second matter was the question of intention that's waived.
If you go on 64, it goes on to discuss temporary absence while on holiday in advance of service or trips across the border to Scotland. But you can't equate this exclusion of Mr. Fridman with being on holiday or with a trip across the border, can you? He's been out of the jurisdiction for 6 months, cannot come back. That is, you must accept that as a considerably more serious absence than holidaying or popping out for lunch.
I accept that that's a more serious absence, and I'll deal with the lunch or holiday point expressly if I can. But even though that's a more serious quality of absence, it can still be a temporary absence, as Mr. Justice Bryan
It's
found.
indefinite, isn't it?
Well, it's indefinite until Mr. Fridman's extant legal challenge to the sanction is successful, which Mr. Justice Bryan noted could be at any moment, such that his intention to return can be fulfilled in the context of a defendant who has retained a residence with staff, with his post being collected for his return.
As and when his challenge succeeds, at that point he may well be present again.
Indeed.
It doesn't mean he's present until then.
Well, what one is trying to establish, what one is assessing is what the situation was at the date of service and whether he was present. And the law permits there to be a temporary absence. And our submission and Mr. Justice Bryan's finding was that there was only a temporary absence. And that was the basis for his finding of fact of usual residence with which this court is back. Can I just deal with the intention point and try and wrap up in dealing with that, the point about the lunches and the holiday? My learned friend takes a point that future aspiration to return to the United Kingdom does not make something true. The argument being that Mr. Fridman's stated intention to return cannot make him present for the purposes of jurisdiction. But that was obviously one of the factors, the intention that Mr. Justice Bryan took into account.
Where does he evaluate the prospect of that aspiration, to use Mr. Craig's word, being put into effect?
Well, he picks up the point in 53 that we looked at. I can't submit, my lord, that Mr. Justice Bryan focuses on any prospect analysis, save that he does observe at 50 in the main body, he talks about the last two lines, in circumstances where sanctions brackets for the time being, so long as they lasted, prevented him from returning. And then at 53, speaks about Mr. Fridman informed Mr. Justice Saney that he intended to return to the UK. A statement was made in the context of his existing challenge to his designation, which might be determined favourably and soon. And then in his conclusions, paragraph 69, subparagraph 4.
Sorry, 69.
69, subparagraph 4 on page 93.
Yes.
He deals with the background of the ongoing challenge to the designation, his intention to return once lifted. Clear evidence that Mr. Fridman at the time of service continued to consider and treat Appellant House as usual residence, to continue his life. And the fact that, and we submit that this is absolutely right and proper to assess the position at the point in time without the benefit of hindsight. At the time of his departure, it could not, of course, be known that the events in Ukraine which led to the designation would continue to apply, or for a significant period of time, or indeed that his designation would continue for a significant period of time. Certainly his conduct shows an active intention throughout and from the moment of designation to have such designation lifted.
Yes.
Would it be fair to say that the concept of a temporary absence, usually, I'm not saying always, implies it's going to be within the power of the person concerned when and whether to terminate it? I mean, if you're going, obviously, for lunch, it's obvious you're going to come back in time for supper. But equally, if you're going abroad, you might be going on a holiday, and that, I think, is something normally of a finite duration, which you, of course, unexpected things might happen. You might be taken ill, you might fall foul of local laws and be sent to prison over the weekend or something. But, I mean, there's still basically something which is within your own control to terminate. Whereas here it's a matter of high politics, which Mr. Fridman is in no position to influence one way or the other. And it's the fact of these very draconian steps being taken against him which leads to the dilemma he finds himself in, which is, and just to say, and well, he intends to come back if and when it's possible for him to do so, is arguably too open-ended and favourable an approach to what is meant to be a limited exception to the principle that requires actual presence in the jurisdiction.
I have to accept that the holiday or the lunch or the trip to Calais scenario is, the return is within the control of the individual making those trips. But I would say this, that the question of intention is still relevant even in those cases, because if a defendant did not intend to return after their lunch across the Scottish border, then that absence would not be temporary, it would be permanent. Equally, an
Yes,
intention.
I don't think anybody's saying that intention is irrelevant, but if you are going to give it any weight, you need to evaluate whether it is possible, at least, for the intention or the wish to be implemented.
And to answer that, I suppose Mr. Justice Bryan was operating on an assumption that it was possible that intention would eventuate by reason of the legal challenge that Mr. Fridman had made. If Mr. Fridman was a sanctioned individual who had not launched a legal challenge, then there was no possibility of that intention eventuating.
Yeah.
The only possibility of that intention eventuating would be if the sanction fell away because global political matters meant that the sanctions regime itself fell away. But this is an individual, we say, I'll come back to my spectrum point, this is an individual who is making a challenge, and it was right for Mr. Justice Bryan to take that fact into account. And by reason of having launched a legal challenge, it was possible that that intention would eventuate. So the question for this court is, was Mr. Justice Bryan's decision wrong? That the common law requirement was satisfied. His inquiry was plainly a multifactorial evaluation. We say it involved careful consideration of, an application of, and balancing of multiple facts. He demonstrably took into account, as he was required to do, all the matters concerning Mr. Fridman's designation under the sanctions regime, including the draconian effects of his inability to return for an indefinite period, and balanced against them, again, we say as he was entitled to do, the evidence of his intention to return, his maintenance of a residence here, and his challenge to his designation. And the fact that at the time of his departure, it could not be known that the events in Ukraine, which led to his designation, would continue for a significant period of time. Well, they are my submissions.
Thank you very much. Mr. McComb, do you wish to add anything? Yes, Mr. Craig, do you wish to reply?
I have just a few short points. Just first of all, dealing with the point in relation to presence, whether it was argued, how it was argued, and the effect of sanctions. First of all, I don't accept that I argued presence by reference to a residence test. For the simple reason that if I'd done that, then I wouldn't have been able to rely upon the common law test at all, because the test was exactly the same. I made quite clear before the learned judge that I was taking a preliminary point of presence, and the preliminary point was simply on the basis that in circumstances where Mr. Fridman was prohibited from being in the jurisdiction, he obviously couldn't be present there.
Yeah.
The second point is in relation to sanctions and their effect. I hesitate to repeat what I've said in writing, but I just, if I may, the points that I make in paragraph 28 to 30 of my skeleton, which is behind tab 3, I repeat.
Sorry, 28?
28, so it's page 38 of the bundle.
Yeah.
The first sentence I make is the point which my Lord Justice Henderson made about the temporary absence being something over which one has control. And then that's not a description which can be applied to sanctions. I refer to the various points made in relation to Parliament.
Do we have that document? Was it referred to before the judge? I couldn't find it in the bundle.
No, it wasn't. No. And then we have the removal on the 15th of March of the sunset of automatic review clause. And then we have the various recordings in the Court of Appeal of the effect of sanctions. And then we've got the fact that the appellant has no control over the absence, not casual or transitive, enforced one, which is indefinite and possibly permanent duration. And we say that the stated intention is not relevant. Not only is it, I mean, as my lord said, it's a question of I would like to come back, but that isn't a statement of something which is going to be possible. And not only is it a question just until sanctions themselves expire, but by virtue of the fact that the appellant's leave to enter or to remain in the jurisdiction has been removed, he would have to, once sanctions are lifted, then reapply again, and then that is a question of who knows what might be the position. So it's not just a question of sanctions and that's it. It's a question of then having to reapply.
Yes.
The decision, this is the third point, decision in Key Homes, I don't think it's necessary to take you to it, but that was a case where the judge said there's a parallel jurisdiction.
Yes,
under
there's a
the company.
statutory jurisdiction.
Exactly.
Under the Companies Act.
And it's one also which is consensual, because it's one where effectively the director, the relevant director, has the ability to put his address either in the jurisdiction or outside the jurisdiction. The penultimate point is the point made in relation to the effect of SSL, and why we say it's binding. It is not just a decision on the meaning and effect of the particular provision of the CPR. the ratio of that decision is that the common law requirement of presence survived the introduction of a CPR. And with that in mind, the decision in Kamali can be explained on the grounds that there can still be presence, although there is temporary absence. Now that ratio is not dependent on and did not turn on the facts of the particular case, which is what my learned friend suggested and cited distinguished on the back of. And then the final point to make.
So what do you say in response to his submission that, what's it called? Kamali is directly on point and binding on us?
Well, it's not, because the decision in, because they then have the subsequent decision in SSL where they look at, where they are saying, Kamali may have said that actually the rules have been washed away, but we disagree with that. That's wrong. As a matter of fundamental principle, that's the ratio,
Well,
because the common law
seems to be
principle
what
survives.
Professor Briggs says in the section we were just handed.
So he says,
I mean, does this go to your jurisdiction challenge rather than for fact of service, the way that he expresses it, that you've got a sort of Schrodinger's cat and then one moment you're served, the next moment you're not?
yes. Well, so there's a more fundamental jurisdictional point there, which is made, we've got it in the bundle itself, where you are subject to the jurisdiction of the court until you stake some, if there's a service of process, even if it's defective, until such time as you come along to court and say, I wish to set it aside. And that is effectively what the passage in Briggs says. So you have and the reason you have to set it aside is that until such time as it is set aside, the court has jurisdiction over you.
Yeah.
I mean, just to make that point good, it's in another section of the most recent edition of Professor Briggs's book, and my lords will see at this at page 748 of the bundle.
Sorry, just a minute. This is tab 33.
Tab
is it?
34.
34.
My lords, it's page 748, and it's subparagraph 6. You will see within the jurisdiction means physically located, and then if a defendant can be found within the territorial jurisdiction as thus defined, claimant may serve him or her with process as of right, without anyone's position, once served, even if imperfectly, irregularly, or very defectively, the defendant is subject to the jurisdiction of the court unless and until he disputes jurisdiction.
Yes.
Well, and then finally, the Rules Committee point. Now, my learned junior has, in the interim, found the decision of the House of Lords in Massery Contractors, which I can hand up, because it probably completes the point. But what it effectively says is that the rulemaking committee does have a power to extend at least extraterritorial jurisdiction. My lords, it's looks like a very long judgment, but actually most of it is the Court of Appeal's decision, and I apologise that it's not stapled. And just so our lords see where this case, it's at page 133 of the judgment. And again, I apologise that it's not stapled.
133. Scope of
133,
rulemaking power, yeah.
paragraph 9, my lords will see the issues, and this is in relation to the language of another CPR rule, but it's paragraph 3, whether if it does, it's ultra vires the rulemaking power, and then Lord Mant starts at paragraph 10 with the third issue, which is the rulemaking power. He then refers to the principle of construction at letter F. And then you will see that in paragraph 12, the argument was in relation to extraterritorial jurisdiction.
Sorry, where are you now?
Paragraph 12, apologies,
12,
this is
thank
page
you.
134. And there's a reference to various statutes which were relied upon for establishing extraterritorial jurisdiction. And then paragraph 13, you'll see with regard to the heads of extraterritorial jurisdiction involved in what used to be RFC Order 11 is now Part 6. Mr. Layton was able to trace many of them to express statutory provisions, but not all of them. And then you'll see at paragraph 14, Lord Mant says, in those circumstances, I find both unpromising and unattractive the submission that rulemaking power in respect of extraterritorial jurisdiction is limited to matters covered by specific statutory authority. But then we have at paragraph 16, which is the next page, 136, I turn to the scope of the rule actually made. I accept Mr. Layton's submission that even though the rulemaking power is wide enough to enable rules to be made relating to examination officers who is outside the jurisdiction, the presumption against extraterritoriality still applies.
Sorry, Mr. Craig, where?
Apologies, paragraph 16.
Oh, 16.
16, apologies.
Yes.
The presumption against extraterritoriality still applies when considering the scope of CPR Part 71. So in other words, the existing presumptions survive generally, or at least that should be the starting point. And so that's precisely what I say in relation to 6.9. The presumption that the common law rule survives is one which, in my submission, is still there. There's nothing in the rules which cuts it out.
There's another way of putting that point to say that it's a principle of such a long established and fundamental nature that, I mean, even if technically the rule committee could introduce a rule which went contrary to it, it would require clear wording to make that apparent.
Absolutely, yes, because there's a difference between what's been considered here is the extension of the extraterritorial jurisdiction, which one can understand why you might want to give a rule-making committee.
Also wants to fine-tune the provisions from time to time.
Absolutely.
And experience will show that what the rules committee has said in year 1 may not apply or be helpful or may need revision anyway 5 years later. I mean,
Precisely. Yes.
But it's perhaps really, it's not a, I mean, the force of the point is rather that since one doesn't, at least I haven't found any express reference to the underlying territoriality principle anywhere in the text of the CPR, should one, so to speak, take it as read unless it's clearly excluded? I think really the thrust of your submission.
Absolutely. Yes.
Thank you.
Well, unless I have any further questions, that completes my submission.
Thank you very much. Mr. Hayman, do you want to say anything about Masry?
No, my lord. It's a point that I wasn't anticipating taking because it wasn't a point that was expressly taken by my learned friend as a point on the appeal. I've only just seen Masry at the same time that my lords have seen Masry. Can I take the opportunity to consider it, and if there is a point that we need to take in response, take it in writing after the event?
Yes.
I'm great.
Well, thank you very much for some very interesting arguments. It will not surprise you to learn that we will reserve our decision. You will get a draft or drafts in the usual way. They will be accompanied by a fierce embargo, which means what it says, so they can only be distributed to those on the list that the court has been provided for. It'll be your opportunity to correct our English, but not our reasoning, and not to introduce new points subject to anything you might want to say about Masry, and only Masry. we would hope that in the light of the judgments you will be able to agree a form of order disposing of the appeal. But if you can't agree a form of order, please make short written submissions and we will make the order that we consider to be appropriate. Thank you very much.